Welcome to The Explainer. Imagine for a second that you viewed the United States Constitution not as a set of lofty moral principles, but strictly as a chessboard. Well, today we are unpacking a really fascinating, highly strategic text by Kaiim called the Grandmaster's Gambit. And what makes this document so unique is its absolute, almost clinical focus on strategy. It doesn't tell you what to think or how to feel about the current political landscape. Instead, it offers this strictly objective analysis of how political actors navigate massive shifts in voting rights law. So we're going to explore this playbook together, looking at the legal system purely in terms of available, actionable moves.
Here's a quick look at our agenda. 1. The board has changed. 2. The historical context. 3. Old rules versus new rules. 4. The state court trap. 5. The race-neutral gambit. And 6. The 30-year endgame.
All right, let's jump into Section 1. The board has changed.
So our analysis actually kicks off on April 29, 2026. That is the day the legal board was entirely reset. According to the masterclass, the 6-3 Supreme Court ruling in Calais v. Louisiana struck down a majority black district and completely changed the standard of proof under Section 2 of the Voting Rights Act. Now think about what this means in the real world. Before this ruling, if a voting map demonstrably wiped out minority voting power, it got struck down. The results basically spoke for themselves. But this Calais decision raised the evidentiary bar significantly. Suddenly, plaintiffs have to prove discriminatory purpose. Basically, you have to find a smoking gun. You literally have to prove the mapmaker sat in a room and explicitly intended to discriminate based on race. And as you can probably guess, sophisticated political operatives rarely leave a paper trail like that.
Justice Elena Kagan actually saw exactly where this was heading in her blistering dissent. She argued that modern mapmakers can easily hide their motives, which makes this new intent requirement almost impossible to satisfy. She warned that Section 2 would become, in her words, a dead letter, meaning a law that technically exists on the books, sure, but is practically unenforceable in court. Why? Well, because clever mapmakers will just use other, completely race-neutral justifications for the district lines they draw, cleanly sidestepping any accusation of discriminatory purpose.
Moving right along to Section 2, the historical context. To really wrap our heads around why the author asserts this recent legal shift happened, we gotta zoom out a bit. Daids grounds their premise in historian Carol Anderson's definition of white rage. Now, Daids is very careful to frame this, not as a subjective insult and not as extra-legal violence, but as a highly calculated legal mechanism used to preserve a governing advantage. It's a reactive, structural response to a perceived loss of social or political status. The idea here is that when one political party's power is threatened by rising minority representation, they don't break the law. They just use the machinery of the state, the lawyers, the legislators, the judges, to rewrite the law.
And the author tracks a crystal-clear historical pattern to back this up. Literally every major civil rights advancement over the last century and a half has been countered by a structured legal maneuver to nullify it. You go from the progress of Reconstruction, hitting the immediate brick wall of Jim Crow, to Brown v. Board sparking massive school closures, all the way down to the 2020 census demographic shifts, resulting in the Callais decision in 2026. The author uses this timeline to show us that structural pushback is entirely predictable. It's not some crazy anomaly, it's just the opposing player making their move on the board. So the question becomes, how do you play against a move like that?
Which brings us to Section 3, old rules versus new rules.
Because of this structural pushback we just talked about, the old strategies, they're totally dead. Plaintiffs have to adapt to a completely new legal reality. Under the old rules, showing the effect of racial vote dilution was your winning ticket. But under the new rules, you need that smoking gun of intentional bias. The Calais ruling essentially imposes what we can call a blind map requirement. Think of it like this. If mapmakers submit an alternative map to show a fairer configuration, but the opposition can prove those mapmakers looked at racial demographic data even once while drawing it, the court can disqualify the entire map as an unconstitutional racial gerrymander. The data itself has basically become radioactive.
Let's look at Section 4, the state court trap.
Okay, this is where the whole chess metaphor gets super interesting. The first major tactical countermove relies on this incredible legal asymmetry. To survive in federal court without triggering that new Calais intent violation, a rational mapmaker is never going to admit to targeting minority voters, right? Instead, they'll pivot to politics. They will stand up and claim, hey, we drew this map to help Republicans. And why does this work? Well, because in a previous Supreme Court case called Rucho v. Common Cause, the court ruled that partisan gerrymandering is a political issue, not a federal court issue. It acts as an absolute legal shield. But the Grandmaster's playbook turns this exact defense into a fatal vulnerability.
Here is exactly how you execute the trap. Step 1. You force the mapmakers into federal court and get them to publicly admit their partisan intent, allowing them to secure that federal shield we just mentioned. Step 2. You take the transcript of that exact admission, you skip the federal courts entirely, and you file a brand new lawsuit in state court. Step 3. Checkmate. You use the mapmakers' own words against them to strike down the map under stricter state constitutions, citing their free and fair elections clauses. This isn't just theory either. Activists successfully did this exact thing in Pennsylvania and North Carolina. The mapmakers cannot have it both ways. The exact shield that saves them federally completely destroys them locally.
On to Section 5, the race-neutral gambit.
The author proposes a secondary strategy here, and it's derived straight from corporate America: market segmentation. Using explicit race data to draw a map carries unbelievably high legal risk right now. But what about race-neutral data? Think about how companies target ads to you based on your zip code, your income bracket, or your daily commute. Using geographic and economic data carries almost zero legal risk. And yet, because demographics and economics heavily overlap in America, these low-risk datasets can achieve the exact same representational outcomes, completely bypassing the new federal restrictions. It's a brilliant workaround.
By leveraging free geographic information systems, or GIS software, to map these specific race-neutral community interests, mapmakers can create what are essentially bulletproof people's maps. You group neighborhoods by shared consumer profiles like Nielsen's Prism data, physical transit lines, or income and small business loan data. And because you never once looked at racial demographics, you comply perfectly with the Supreme Court's blind map requirement. A map drawn without racial data cannot legally be accused of racial intent, period. It is a completely lawful bypass of the roadblock. Finally, Section 6, the 30-year endgame. This brings us to the Grandmaster's 10-move sequence. Listen, you don't play this game for the next election cycle, you play it for the next generation. It is a disciplined, 30-year strategy. It requires sacrificing those unwinnable arguments under the Voting Rights Act right out of the gate. You just have to let them go. Instead, you spend years building an undeniable, documented history, a legacy ledger. Of economic communities, you submit your race-neutral maps early, you trap opponents in state courts, and you maintain constant vigilance through local watchdog groups. And then, you wait patiently for the moment the opposition overreaches and accidentally leaves that smoking gun of intent. The masterclass insists that while this structural work is undeniably difficult and honestly pretty slow, the alternative is proceeding without a strategy against an opponent who has been calculating their own moves for 30 years. Complaining that the rules aren't fair, that doesn't win the match. The Grandmaster plays the board as it is, perfectly adapting to the reality on the ground to find those winning lines. As we wrap up this explainer on the shifting landscape of constitutional law, I want to leave you with a provocative thought to chew on. Whether you totally agree or completely disagree with the premise, the structural rigor of this playbook is undeniable. So, given the board as it now stands, what moves remain available to you? Thanks for joining me on this deep dive today, and keep analyzing the board.